Hello, thanks for joining me. I'm delighted to bring you the next in the series of Revcelerate Talks. These are short talks followed by a Q&A with experts in my network that are designed to help us become better salespeople. This week, lawyer Dan Adams talks to us about working with contracts. Dan has been on both sides of the table, both as a lawyer and a business development operator. In this talk, he shares ways for us to get the most out of our relationships with our legal teams. He shows us how to present a contract to a client, and he talks about learning when to pick the right battles during a negotiation. He also addresses some of the more mysterious parts of a contract and to help us better understand things like liabilities and indemnities. Now, if you're worried that it might be a bit dry, don't, because Dan provides a really unique perspective and he follows that up with further insights in the Q&A. We join him here talking about the role of the lawyer and the level of risk that your business is willing to take. Enjoy the talk.
Which is fine, but it means that contract negotiations can be quite challenging. There are other companies I work with that will almost frankly sign anything because it's really important to them to get the deal. So the role of the lawyer is, or should be, pointing out what the risks are to make sure that the salesperson and the business understands them, but not necessarily saying no and getting in the way. And I think that's often confused. And I think lawyers can often say, no, you can't do this. And actually, that's not always the case. So, what legal risk you're willing to bear as a business depends on all sorts of factors. So the stage of your business is one of those important factors. So, when I work with, for example, Expedia, who we do a lot of commercial deal support work with, they're a large company. And frankly, the companies they work with need to work with Expedia more than Expedia needs to work with them. And so they have a very different attitude to legal risk to some of the startups we work with that just need to get the deal done. Because frankly, if the deals don't get done, then they're not going to raise their next round. They're not going to get enough cash in the door to be able to operate in 6 months' time. So understanding that's really important. Other factors are how big the deal is, and also what type of business or product or service are you offering. Is it something that's critical? If it goes wrong, does your client fall over? So if you're offering, let's say, a technology solution to a bank, and if the technology breaks down, that the bank then can't process transactions, that would be a hugely critical element of a service that your customer can't operate if you fall over. But actually, oftentimes that's not the case. And so thinking through these issues is really important before actually negotiating a contract, and making sure that whoever you're working with as the lawyer to actually negotiate these contracts understands that. I don't know if you have anything to add there, Phil, or anyone. I'm trying to make this interactive, but I can keep going unless anyone wants to say
Yeah, I suppose that point about you sometimes feel that when you get involved with a legal team that they have the final say over what's acceptable and what's not acceptable. And that's not the case. I mean, as the commercial person, you're the one making the advice, the recommendations to the business about what you think you should do, but you need to understand the consequences of going down either path. And that's really where the legal partner helps you, because they will explain the interpretation of the language that will mean that you can make a clearer decision. But they absolutely shouldn't be trying to stop you from bringing the deal, or certainly dictating the deal terms. That's why they employ us. We're the ones who understand the commercials. And it's the partnership. Yeah.
It's interesting. I've seen, so obviously there's companies that don't have internal legal teams and they'll use an external lawyer. And in those cases, the dynamic can be quite different to when there is a legal team, an internal legal counsel or team within a company. And then in those instances, sometimes those lawyers are almost set up to act as a brake on the sales team. Because obviously there's a conflict, right? In terms of, the sales guy wants to get their commission, hit their targets and so on. The lawyer doesn't want to take any risk. And so it's much easier. It's always easier for the lawyer to say no, or to err on the side of saying, not sure we should do that, and therefore pushing back. And actually, I think in my experience, the good lawyers are the ones that are very commercial, very pragmatic, understand your business, and are willing to take that risk. And often, and unfortunately, it does come down to experience. I think quite often you get more junior lawyers who are a little bit more reluctant and will say no. And that's another point actually. When I look at a contract that's been marked up from, in a negotiation, let's say our client has sent a contract and it comes back with lots of red line. I always look at the profile of the lawyer if I can. I'll spot their name if it's not on an email. I'll see them in the comments or something, and I'll look them up to understand where their perspective is, because it's only an indicator, but you can get a sense from even from their LinkedIn profile as to how qualified they are and how likely they are to be pushing back on the big issues or just picking fights for the sake of it. So it's important to have that context. So the next thing I wanted to talk about was template contracts. It surprises me how often I work with clients and they'll be ramping up. So we work with lots of companies that are sort of scaling up. They've had Series A investment and so on, and they're now growing their sales team and really pushing ahead, but they don't have a good legal template. It's really important, obviously, to minimize legal friction at the contract stage and close a deal quickly. Ideally, you want to have a good template, and I always think of a legal contract template not just as a kind of legal thing, but actually as part of the sales collateral. It needs to be considered as part of the messaging that you as a salesperson are sharing with your prospective client. And it needs to be drafted in a way that they will understand it and it will tick their boxes. Obviously, it depends on the type of client that you're going for. And I don't know on this call, obviously there's a range of different people working for different businesses. And obviously they'll have, you'll all have different customers. But if those customers, for example, are large corporates or government organizations and so on, and they're high value deals, there'll be procurement teams getting involved. Those procurement teams, or the way that those companies or potential clients look at contracts is different to other types of people you might be selling to, like smaller businesses or consumers. And so thinking all that through when you're creating a template and making sure that you are accommodating what they want, because if you don't accommodate that, then you'll get lots of pushback and you'll end up not using your template. You'll end up having to use something else. And also I see a lot of templates are really aggressive and one-sided. They're obviously drafted by the company that's putting it forward and offering the service, but if that's likely to be reviewed by a lawyer or someone on the other side, and it's just littered with we're not going to give you this, we're not going to give you that, and disclaim this and disclaim that and so on, then all it does is again raise eyebrows and create pushback. And at worst it creates slows down that sales cycle, but it could potentially jeopardize a deal. And it's a basic point really, but contracts really should be simple to read, not in Latin. You still get Latin terms in contracts, and really succinct. I pulled out an example. This is something I saw very recently, a confidentiality clause within a contract. On the left, this was one that I was given the other day, 834 words, compared to the one on the right, which I actually drafted and I use as a template, which is 78 words. Now, I'm not saying that sometimes you need to be a little more thorough and robust, but it's about knowing what you need to say. But to be honest, 99 times out of 100, I would say you only need those 78 words rather than the 834 words. And so, if you've got one clause that's 834 words, and then you've probably got 30 or 40 clauses, that's a lot of reading, and that's a lot of friction at the contract stage. The other part with templates is thinking about how you present your contract, when you present it, and how it's presented. It's really basic stuff, but I've seen so many times, a salesperson send a contract as a Word document to a customer, and that's just an invitation for them to read it and mark it up. Now, I appreciate sometimes you need to send it like that, and it's very hard to talk in the abstract here, but it's amazing, just basic things like sending it as a PDF, or again, it depends what you do. But another thing that some of my clients do on our advice is to try and separate the commercial terms from the legal terms by way of an order form, and then actually have the T's and C's hosted somewhere else, so on a web page. So this works quite nicely for SaaS businesses, where you have, a salesperson can create a really simple order form that says, this is the name of the customer, this is the service we're offering, this is how much it costs, and so on. And then, that can be really simple. And at the bottom, it just says, this is subject to our T's and C's, and that links off to a web page. And hosting that on a web page, again, it just, it's presented as, this is how we work, and this is how our hundreds or thousands of customers, work with us. And it doesn't really give an opportunity to negotiate. Now, again, this doesn't work all the time. Of course it doesn't. But this is just one way that it does work and can work effectively for some types of businesses.
And Dan, quick question there. Have you seen that method used for bigger, more complex contracts? So I mean, by enterprise level contracts where maybe there's a material investment taking place. Have you seen it been used in that context?
Yeah. I've seen it in all. Yeah, it doesn't really, I mean, it depends on who the customers are and what the nature of the services is. So it's hard to say, but it doesn't work for everyone, but it certainly works in many contexts. And it's a way when, if you start having, hundreds of customers, it's actually a really good way to manage those contracts too, because, I haven't talked about contract management in these slides, and maybe that's a topic for another day. But when you do start to think about, you've got a bunch of customers, they're all on, different terms because you've signed them up at different times. You need to be very aware, or someone in your organization needs to understand when they're coming up for renewal. And again, it's so often the case that, contracts coming up for renewal and you haven't really remembered until the last minute, if you remember at all, to actually pick up the phone to that customer and figure out, are they happy? Are there opportunities to upsell them additional services? Can you increase pricing and so on? It just kind of, falls by the wayside. And when you start to have lots of different contracts, if you have an order form that's just, a one pager, you can quickly see what you've done with each contract rather than having to plow through, 30 odd or 50 odd or whatever number of contracts that are all 100 pages each. They're really hard to get through.
Great, thanks.
The next slide was how to get the most out of your lawyer. So one of the things I see a lot is this kind of, the sales guy does the deal, agrees the numbers, and then says to the lawyer, right, here you go, you do the contract. And then it's actually really hard for a lawyer to handle that, because actually, most of the decisions that need to be made in a contract that are often considered as legal issues are actually commercial issues. Things like, how does the termination provision work? Is there an auto renew? At what time period does that kick in? And, what are the liability caps and so on? These are all, they're not things that a lawyer can just necessarily go and figure out on their own. So I think you need to really consider working in partnership with the lawyer, which so often doesn't happen. I've talked a bit about this already, but it's really important that your lawyer understands the level of risk that your business will tolerate, and actually understands your business and understands what the actual risks are if things go wrong. Obviously, the lawyer's there to look at the downside and to think through, well, what happens if this goes wrong? What's the liability? But sometimes you can go down the garden path arguing over an issue which is just a non-issue, because the reality is that can never happen because of the nature of the service or whatever. And so it's really important to make sure that your lawyer understands what the realities are there, so that they can be pragmatic and not waste time. And also avoiding red line for the sake of red line. This happens, I think, more when you're working with lawyers who, you're paying an external law firm to do some work for you. They're probably charging you a fair amount of money and they need to demonstrate they're adding value. And so often it's easy for the lawyer just to kind of, take a red pen to things and start marking up documents really heavily. And I always try and make sure, if I'm doing that, that I explain why I'm doing that. And so, if it's a Word document, use the comments section and make sure that they are giving some rationale for whatever they're doing so that you can understand that. And also when it goes over to your counterparty, so that they can understand that. And this, I guess, is a related point. It's making sure that your lawyer is actually focusing on the clauses that are the important ones to focus on, which I talk a bit more about here, around sort of picking your battles. It's really hard to talk about this in the abstract, because obviously a contract, all contracts are different depending on the nature of the business that you have, the products you offer, the services you offer, the risks, and so on. But the last few slides I've got here are just talking about a few of those clauses, only at a really high level. It's quite dry talking, too much around contracts on these types of calls. But I've picked 3 clauses: liability caps, indemnities, and term and termination rights. So liability caps. So the whole point of a contract really is you need to make sure that you have a balance between the risk versus the value of the contract. So, if a contract is for £10,000, do you really want a contract that gives you a potential downside risk of £10 million? And these are the types of things, and this is why a business needs to understand what the risks are and how they balance with the value that they get from a contract. Maybe that's a liability cap that they would consider, and maybe it's fair, I don't know. Often you see, and you should see, a liability cap that's somehow tied to the value of a contract. So quite often you'd say, okay, well, we'll be liable to you if we do something wrong and we're in breach of contract, but the total liability we'll have is somehow linked to the value of that contract. So maybe it's linked to the value of the fees that we would get from providing you a service over the last 12 months. But also, understanding, what are the actual risks of things going wrong. So, maybe you do have a liability cap. I see this with startups. Again, I'm thinking of one of my clients is a SaaS platform providing a video technology software solution. And they've got some really big brands and big customers that they're working with now, which is great. But those lawyers will say, well, we can't, the fees of a deal might be, I don't know, between 20 to 50,000 pounds per year. And we try to put in a liability cap to say it will be at 12 months fees. But because the fees are relatively low, let's call them 50K to a large corporate, that corporate says, well, hang on, there's no way we'll accept a liability that's only 50K. So actually though, what I asked was, well, okay, so let's say you accept a liability cap of £5 million or £10 million. What are the scenarios in which actually something goes horribly wrong and there is a liability of £5 or £10 million? And actually, we couldn't think of any. So then it becomes, well, let's be pragmatic here. And let's say, okay, well, let's not worry about a liability cap that on the face of it looks way out of whack with the value of the deal. But actually, these guys aren't going to shift. They need to, you understand the liabilities more than they do. So it's your place to take those risks. And other factors like what can you back off to your PI insurance? So, these are some of the things that often come up in conversations around liability caps. Related is indemnities. I think people are confused around what indemnities are sometimes. So just to quickly explain, an indemnity, the quickest way of describing it is a gold-plated way for a customer to recover a loss. So when you recover damages, there's certain restrictions on the amount of damages that you can get. And this is all, I won't go into the detail of case law and so on, but there's certain limitations on those damages, whereas indemnity effectively is more like an insurance policy that gives you a benefit of anything that you've lost money on. So an indemnity is a very powerful remedy for a customer if something goes wrong. And they're often also carved out of a general liability cap. So a contract might say, there's a liability cap of 12-month fees or £1 million or whatever. But then the indemnities are either subject to zero liability cap or a some kind of super cap. So you need to make sure that those indemnities are really only for particular heads of loss, particular scenarios where you understand, because the loss is so high potentially. So things like a promise that if your customer is using your service, they're not going to get sued by somebody who comes along and says, well, actually, we own the IP in this service, not and we haven't given you the right to do it because you've stolen that IP. So things like that are often and typically an uncapped liability. You get things like data protection and GDPR sort of related issues. Again, that's a whole conversation area in its own right. With GDPR legislation that you're probably mostly all familiar with, there's now super high potential fines on companies for data breaches. And so lots of people are very excited all the time when they look at a contract around what is the liability cap for data breaches. And customers can be very strict and demanding around wanting uncapped liabilities. And sometimes this can cause massive issues in contracts, I've seen. But again, it comes down to sort of that balance of risk and upside. I'm just going to talk a bit about this last clause because I feel like this all gets very dry very quickly. But term and termination rights. This is another area that's of interest and sometimes heavily negotiated. How long do you want to lock your customer in for? To what extent do you want to allow them to automatically have a right to break the contract, or that the contract expires after a year, or they can terminate at any time on 3 months' notice? Auto renewal clauses are something that are great for suppliers, but less good for customers, because they'll say, the contract will automatically roll into a new year or a new 3-year deal or whatever it is, unless you remember to terminate at least 90 days before it expires. Otherwise it renews. So these types of things are great tactics for you to get a longer term deal. So you present a 12-month contract, but it effectively becomes an ongoing contract because people forget to terminate. That has consequences for how do you increase your pricing, and there's mechanics for that. I feel like I'm probably going into a bit too much detail here, and I might lose you if I haven't already. So I think I might stop there. Does anyone have any questions on any of that?
Dan, this is great. Thank you. There are a lot of things there that sort of struck me as you were talking, particularly this whole piece around contract friction as something that we have to deal with, particularly for the more senior commercial leaders in businesses. At the level that I tend to operate, it's part of the job is identifying and removing points of friction in the deal process. And when you look at contract friction, maybe there's a mindset that yes, you've got to get through it. And you've got, and there's a lot of pitfalls on the way of agreement and contract. But it's an important part of closing a deal. And thinking about that and thinking about how to work in partnership with your legal team will just really remove or certainly eliminate or reduce the effect of that friction. So I thought that was really, really good advice. The whole idea about separating commercial terms from legal terms as well, I've seen that work to great effect in a number of companies as well. We used to use it a lot in the media space. I mean, advertising was built on this idea that you signed an order form, but the T's and C's sat in the background, and that's where all the kind of difficult stuff used to live. Well, in a developed industry like that, no one really looked at T's and C's, so they just signed the contract and off they went. So I thought that was really interesting and certainly something that you should do. And it's just about getting that up on the website, isn't it? About having a link so you can point to it. And we've certainly done that with some of the businesses that are on the call today as well.
Yeah, on that point, sometimes customers clients are reluctant to post those T's and C's online because they think, well, this is sensitive information. We don't know whether we can share it. I personally don't see it as a huge issue, but sometimes what customers do is it's hosted on a publicly available site, but it's something that's not signposted from the website. So you need to know the URL to find it.
Yeah. I think that the whole kind of indemnities piece, that's the black arts, isn't it? The dark arts of law. I mean, we look at those indemnities and they're just mind-blowing, both in terms of the size of the fines and particularly around things like data protection with GDPR, which is 4% or 20 million for every single breach of GDPR, which if they're putting that onto your business can obviously seem like a pretty big threat.
The thing to bear in mind on that is because everyone knows those headline numbers and everyone gets scared, and that's that. I guess that's good that people are concerned, but also to understand the likelihood of getting that kind of fine. I mean, you have to be doing something pretty awful. Google's had a couple of big fines. There's been a few high-profile fines like British Airways and others, but they haven't been, and so they haven't been anywhere near as high as they could be. And so, in the main, it's about being pragmatic and knowing what those risks are, rather than just being afraid because you hear a big number, which is often the case.
And that's typical of insurance, isn't it? It's the threat of what might happen suddenly becomes the reason why you take out that insurance to cover it. But it is perhaps the most complex aspect of contract law that I've had to deal with is really getting into the indemnities, and that's where your legal partner is a great help. I also like the idea you had about managing, really understanding the risks of the business around the liabilities. Getting your counterpart to explain the situation where the liability cap that they're suggesting will ever come into play. It puts the onus back on them. And in sales process, it's a two-way conversation about, define problem, solve problem, kind of through what you've got. I like that idea and working with legal partners to say, well, let's figure out when this is likely to happen. And if it's not likely to happen, let's just set it at a reasonable level and move on. Great. Really great insight. Thank you, Dan. Does anyone have any questions, comments, thoughts they want to share?
Hello, it's Frederick. I'm based in Switzerland. I worked in procurement for quite some time, and now I'm doing advising for startups, so small organizations. So it's a great presentation, Dan. It's very nice to see that. It wasn't as dry as you make out, but it was good.
Thank you.
I had a question. So I mean, I've seen contracts that are very big because I work for an American organization, and they like putting a lot of blah blah in it. And then you've got Swiss organizations where maybe the contract is 2 pages long, so it's the opposite. My question would be: so for somebody who's looking for a lawyer, what criteria would you recommend to use to choose the right lawyer?
I think recommendation is always important. There's many lawyers out there. I think people that understand the industry sector as well that you're working in is important, because a lawyer, as I try to sort of say at some point, it's important that the lawyer understands how your business works in order to give you good pragmatic advice. And so I believe that they need to understand, the sector, and therefore have a better idea of what you're doing as a business in that space. You've got to be careful. So, if you work with a big law firm, for example, there's always a temptation to work with say a Magic Circle law firm. And, I've worked in some of these big law firms myself. And what happens is you're sold you take some comfort in the brand of the law firm, but actually the work is carried out by a junior lawyer or even a trainee lawyer. And the partner who sold you the work is, on the golf course and really has no idea about what's going on in the day-to-day. And that's a challenge. So I'd always ask a law firm who's actually doing the work, not, because it probably won't be the person that you've spoken to initially.
Yeah, good advice.
Great. I've had exactly that problem. Thank you again, Daniel. Really good presentation. And as I agree with Frederick, not dry at all. Really useful.
Oh, thank you.
One concern I have, when you mentioned indemnity, I thought of a number of NDAs I've signed over the years, in my own name. I don't know whether I'm protected because it's from a limited company, or whether I've got indemnity on myself personally, having signed all these documents. Could you just talk a bit about NDAs and any sort of gotchas on those, and how you could maybe help us not to sign these, because I don't often get a choice.
No, I mean, so NDAs are an important document in terms of making sure people understand to treat information that they're sharing appropriately, because it's, you know, confidential. Actually, I don't know of many cases of when NDAs have actually been enforced. From a legal perspective, they're very hard to enforce. So I think they're more important in terms of positioning than they are necessarily in terms of enforceability. Some people say that they're not really worth the paper they're written on. Now, I think that's probably going a little bit far. So I, you know, that's one thing to think about. I always think, you know, if you're a small company or an individual and you're presented with an NDA, and, you know, sometimes I get asked to have a look at these. If I always, the first thing I see is it a one-way NDA or is it a mutual NDA? By which I mean, are you the only person that's bound by this, or is your counterparty also bound by it? Because if that counterparty is sharing that document with you, if it's a one-way NDA, it's likely to, or potentially likely to contain much more onerous provisions than if it was a mutual one, because, you know, they won't want to bind themselves to onerous terms. So I would say, as a quick tip, make sure that you get a mutual NDA if you're being sent one, because, you know, most likely then it will be pretty balanced in the first place. Sometimes those mutual NDAs are sneaky, and there's ways through sometimes in definitions, or, you know, things creep up in places where they wouldn't be expected to, which effectively, you know, puts more onus on one side than the other. So there are still tricks that people use. So you really need probably a lawyer to give it a quick once over, just to be on the absolute safe side. Yeah, I think the quick tip would be make it mutual.
Right, thank you. I'll sleep better knowing that. One other quick follow-up, if I may. You mentioned about the not worrying too much about the amount of liability that you have, and that your professional indemnity insurance would take care of that. I've had some recent problems with a US client where I had a particularly high amount of liability, which I wasn't worried about for exactly those reasons, but my insurance premium then jumped massively. Are there any pointers or anything you could do to help me if I was in a situation again, to reduce my insurance premium by rewriting this contract in some way?
I think you can engage insurers. You know, for high value contracts, often clients will go to an insurer and say, look, this is the deal. You know, are you happy with these terms, to make sure that they are properly covered? You know, we all know insurance companies are loath to pay out. So I wouldn't always want to rely on an insurance policy. Just to pick up on what you said, you know, I don't mean to be too casual to say, don't worry about liability because it's covered. It's more, it's just understanding it within the context rather, you know, so it may be something to worry about or it may not, but I'm saying it's not necessarily something to worry about. I certainly wouldn't want to always rely on an insurer. You know, I'd never like to really rely on an insurer. And, you know, frankly, when you see, I've actually worked quite closely with a big insurance company. I won't mention their name on here, but, you know, I'm quite familiar with their policy wording and all the carve outs that they have. And, you know, frankly, I wouldn't want to be relying on them ever.
Yeah.
Okay. Thank you.
Sorry, it's probably not a helpful answer, but
I won't sleep as easy now. Thank you. Thanks.
Yeah. One thing to add just to the NDA thing, because it's often the first contract work that we'll touch as a salesperson, you know, get the NDA signed, and either you fall into one or two camps, which is that it's, you know, it really doesn't mean anything and therefore just get it done, or, you know, what am I signing up to here, and it's a bit of an alien area for you. All I would say about NDAs is that they're a really good measure of trust, and I think that's how I tend to think of them. So if someone wants to entrust you with insights, information about your business, particularly in the early days of a relationship where you don't have a working contract, the NDAs can be a very clear signal. And if it comes from the client, then it means there's a degree of interest, which is perhaps a bit higher than just a casual browse or what have you. So I look at them like that. It's sort of an element of trust. So, I've signed it. It should be a matter of course. It absolutely should be mutual. Better that you have one. And if you don't have one, I have a template you can use as well. Just get it done, move on, get to the next level.
If anyone wants a template NDA, I'm happy to, please reach out. I'm happy just to share something with you.
Nice one. Thank you, Dan. Any other questions? Any questions from our sales people?
I've got a question around reasonableness. So I've got looking at a contract at the moment, and there's a clause, and it's all sort of around this word reasonableness. And it seems to me that the entire agreement can be broken if the other party deem it reasonable. And I'm told that this is a standard clause. Is that right?
So you've either got sort of absolute obligations in a contract, and sometimes you have obligations to use reasonable endeavors or reasonableness or whatever. And you want to make sure that the things that you're expecting in a contract, if you're the purchaser, let's say, are absolute obligations rather than reasonableness. Because at the end of the day, what does that mean? Sometimes the contract will say who determines what reasonable is, and it's either which of you gets to decide that. And ultimately, though, if it doesn't say that, then it would be a court, and that gets very messy. I mean, this is. The EU is now, threatening, or is now, I think they've just announced they're suing AstraZeneca over the vaccines, because I think AstraZeneca said they would use best endeavors to deliver a certain number of vaccines to the European Union, and they haven't delivered them. And they've said, well, we didn't say we would. We just said we'd use best endeavors to do so. And so it becomes very messy. So it always depends on the contract interpretation. So without looking, I'm happy to have a look at your contract, but I would just be really careful about using reasonableness in a contract, particularly for important things that you need to make sure are done.
Okay, thank you.
Yeah, I have another question. So I'm also an early stage investor for startups, and when I talk to startups, I always ask them to read what a shareholders agreement, a purchase agreement, investment agreement, all these things are before we start negotiating, so they actually understand what they're talking about. Is there any resource materials that we can look at to understand what commercial contracts are, the basics? Dummies?
That's a good question. There probably are. I don't know. I don't have any. We're actually thinking about to what extent we can put content on our website that could be helpful around some of these themes. So that will come. And actually, if you've got any particular questions and you think that certain areas would be helpful, let me know. Lots of law firms, if you Google things, if you have a legal question, then there's many law firms that will pop up because they've created content around a particular question. So if you were to put in, what does reasonable endeavors mean into Google, you'd probably find, a dozen articles from a, number of big law, probably hundreds of articles, in fact, and from some big law firms. And, that's probably a good starting point. Lawyers use resources. So I use a resource, and our lawyers use LexisNexis, but we pay, thousands of pounds a year to have access to that. So I don't know what's available for free beyond that content on websites from law firms.
Mm-hmm, mm-hmm. And of course, there's all the difference between the civil law and common law, depending where you're based.
Of course. Yeah. We never talked about contract jurisdiction, but, if you're dealing with, selling a service to companies around the world or multinationals, then there's often some debate around, what is the law that applies to that contract. Now, I'm an English qualified lawyer. I'm not a US qualified lawyer or a Swiss lawyer or and so on. But quite often, I will end up looking at a contract, and then the customer is in New York, and they'll say, well, it has to be under New York law. Then it becomes a question for the client as to whether or not they want another lawyer to look at things. To be honest, I think 99 times out of 100, they'll go with the they won't bother to get another lawyer to look from another jurisdiction. Again, that's a question of being pragmatic or not. Do you really want to double up on your legal fees?
No, okay. Yes, I think from my past experience when I was in procurement, the contract was the piece of paper you take out when things go bad, and you try to negotiate how to resolve the issues up front so that it's clear, so you don't actually have to take out the contract.
Exactly.
Great advice. Thank you, Dan. There was one thing that struck me as I was listening to this, and I don't know if it came from you, but I remember a conversation with the legal team at AOL about how the courts view contracts generally, and it was all about this idea of fairness. And I don't know if I got that from you about kind of really what the purpose of contracts are and the interpretation of contracts when it all goes horribly wrong and you find yourself in a court situation. Did that come from you, or?
I don't know if it comes from me or not, but there are a couple of themes in there to pick up on. One is that, firstly, it all comes down to interpretation of a contract, and obviously there's always shades of grey. Does it mean this or that? And that's why the courts will ultimately determine things, but probably why you don't want to go down that road. If you put a clause in a contract that is a sort of get out of jail clause, but you've hidden it and there's some ambiguity around whether or not that works, the courts, as a principle of interpretation, will always interpret that against the party seeking to rely on it, if that makes sense. So if there's a chance that wording could help you to get out of your obligation, but also a chance that it might not, the courts will always decide on the latter to protect that person. And the other point to bear in mind is that just because something's written in a contract doesn't make it enforceable necessarily. There's lots of laws that will say, well, actually, even if you said this, then that doesn't matter. So you need somebody who understands that. You can't just rely on what the wording is in the contract. You need to understand what the case law is, what the other statutory law is around that particular subject. So a good example of that comes up quite a lot is around restrictive covenants and non-competes. So, clauses that say, if you work with us, then you can't work with anyone else, anywhere in the world for, 100 years. Those types of things, if they are too broad, are not enforceable at all. You can't just throw the kitchen sink in and expect to be able to rely on it.
Yeah, and many will try that. Fantastic insight, Dan. 30 seconds on Arbor then. So what's the story there?
So I've set Arbor up because there's a lot of big law firms that, frankly charge huge overheads and don't provide great commercial legal advice. I struggled to find it as an entrepreneur. And founding my own tech startups. So I've set up Arbor with a few business partners. We now have, I think, around 15 other lawyers working with us. We are far cheaper. I'm not trying to give a whole sales pitch here, but we are much more cost effective than some of the big law firms. If you have any questions and you are a technology, media or telecoms company, and you'll need help with anything on the corporate side to do with, fundraising and so on, commercial contract support, employment advice, data protection, IP, give me a ring.
Thank you, Dan, for a great talk. Please do get in touch with him and the team at Arbor Law if you need any help on that front. And I'll be back here with the new Revcelerate Talks soon. In the meantime, please do pass this on to someone and have a great week. Bye for now.